Claudia, Byrd, given the same hypothetical, this has happened. We can't change the supervisor who may have acted inappropriately in assigning Mary to this job, but you're now, she's now your client. You're going to try to place her in employment. Based on this work history, first of all, there's an attendance problem for a while because she decompensated. There's bad blood, meaning that within the work environment, there's a lot of animosity between the new girl who got the job and the employer who's involved. And of course, Mary is extremely upset. With this kind of work history, what, if anything, can you do to help Mary seek gainful employment?
Basically what I would do, well, with any individual that comes to me, basically I do vocational and aptitude testing. If aptitude testing is not needed, I don't give aptitude testing. I look at the assets of the individual, where their vocational interests are. I'm familiar with the labor market in terms of there are positions that have more public contact. There are positions that have less public contact. A specific instance would be somebody who had a psychiatric disability in terms of getting along with coworkers or people in authority. Their outcome of the vocational objective would be a computer technician. Mm-hmm. Actually a help desk technician, and it pays really well. They are dealing with the public, which they like to do, but it's by telephone. They have memory problems because of the medications that they're taking. There's classes. I mean, I refer my individual clients to classes. There's a new type of behavior modification counseling sessions. There's some at Kaiser where they work with people with OCD or panic disorders. You know, so it's a twofold process of making the employee or my client, you know, responsible for taking action themselves, like read up on the ADA laws, you know, read up on the job market. You know, where are your interests? You know, discussing it openly. It's the rest of your life. I'm only there to give you expertise in terms of would it be appropriate, what I think, and I'm still not capable of doing that. Whether you think it would be appropriate, what the wages are, what's the job market like, what are the breakdown of the job requirements. So it would be just trying to take the person as a whole body, you know, and finding how they could be the most successful. Usually the individual knows, you know, just working, you know, giving research assignments, not just because I'm too busy, but to give the person the dignity and the right to gain information on their own accord. You know, to better understand what's going on.
So your face-to-face interview with your client, the client being the primary source of their abilities and interests, would be a logical place to start. Definitely. It seems to work that better because people going through the system always feel that they're being, you know, forced to go in one area or another. To give them back control, I think it has been the most positive for me.
And there's no legal reason that people have to disclose attendance problems. In fact, that type of information would be private. And a lot of vocational rehabilitation agencies, and probably Claudia Byrd has worked on helping people come up with resumes that positively and accurately reflect people's experiences, including volunteer experience.
Claudia Center, do you have a legal citation for the protections against, aside from being sued, against getting information on attendance records and so forth? Aside from defamation suits and so forth.
Well, I'm thinking about the new employer. A new employer cannot ask the potential employee, how much time did you miss, because of a disability, or what was your, those types of questions are prohibited application questions to the extent that they require a person to disclose a reasonable accommodation or to disclose a disability. So that doesn't mean those questions still aren't out there. There are a lot of questionnaires that do ask illegal questions like that, but they're not supposed to ask it. And that would be, if you looked, for example, on the EEOC website, which is eeoc.gov, and pulled down the guidance on pre-employment inquiries, there's a section about asking about, past workers' comp experience, past leaves of absence for medical reasons. You can't ask about that.
Okay, was there a question from the young lady with the blonde hair?
Good afternoon. Ms. Byrd, I have a question for you. How do your clients find you? Are they referred to you from rehab centers or and also the other question is, does your client place more responsibility on you to find them a job, or do you in turn let them know that they have a responsibility to fulfill the training and going through these things? I'm just wondering, all the responsibilities are placed on you to find jobs for these people. They have to have some kind of effort put forth?
My responsibility, no, because that would be enabling a person, so I wouldn't agree with that. I don't try, it depends on what the individual's needs. My job is to make somebody more self-sufficient, but not scare them immediately. Some people are more independent than others, so it would be sort of like a weaning process.
So you hold their hand and kind of walk them through the process?
It depends. I take each person individually. Sometimes somebody needs to be walked through the process. Hopefully, if I'm any good, that I figure out the way to make them more independent by giving assignments and things like that. I will, let's say, the bottom line is fax out resumes for some of my clients, because if they go to Kinko's or something, sometimes they charge $2 a page. But I will ask them to bring me, the job leads or the names of the employers that they wish me to fax the resumes out to, because otherwise, they, under the system, they wouldn't have enough money.
And how do they come to you?
They can come to me from self-referral. An injured worker, an employee could say, well, I'd like to work with this person. They can come from me from the insurance company, or they can come from me from the Vocational Rehabilitation Bureau. I'd be on an IVE list. Or they can come from me with agreement by the workers' compensation insurance company or the applicant attorney. And if there's a defense attorney involved, depends.
Yes, hi. I had a scenario take place, and I kind of looking for some advice so I know how to pursue any kind of follow-up. I work for an agency who provides pre-employment services to people with psychiatric disabilities. I had a gentleman, I'll give him a false name by the name of Mike, who was an accountant in his past and wants to go back into an entry-level position, and he pursued a certain bookstore. Months and months passed by, and his application sat there, and his resume sat there, and he was more than qualified, maybe overqualified, but nobody would hire him. So I did some cold calling for him and got one of the hiring managers and got the runaround from her, and nothing ever took place. A few months passed by and there was a change in management. And I spoke with the new manager, and I was speaking on his behalf, and I said, I'm a career counselor, and I have people on my caseload, job seekers, and this particular gentleman is interested in the position. And when I said caseload, she said, "Is this a Department of Rehab client?" And I said, "No," I lied. And I said, "No." And from that point on, the conversation went downhill and she tuned me out. And I let her know at the beginning of the conversation he had applied for this position months ago. And I was asking her, "What does this gentleman need to do to obtain an interview from you?" And she said, "He needs to come in and apply for the position," and yada yada. And she like tuned me out and forgot that I already told her that he already applied. So I'm suspecting discrimination. And I kind of don't know what to do from here on out for this gentleman. He's been hired elsewhere in the time being, but I kind of feel like I should do something, and I don't know if I should or should I just let it lie.
I think one thing you may want to consider, or I'll also leave time for the other panel members to answer, is to use a plant. In other words, this person has another job. If you really wanted to pursue this, you might want to consider using a plant. In other words, somebody else who's sent in who can get sufficient evidence, credible evidence, to pursue what you've indicated you want to pursue. In other words, discrimination, and seek a remedy for it. Although it's possible Claudia Center may have a different viewpoint on that kind of technique, but that certainly comes to the top of my mind.
I actually thought about that. I thought about that, but that leaves me with another question. I don't know, I've never had to pursue any legal assistance for any of my clients, so I wouldn't know how to go about doing that. But I also thought about going over that supervisor's head, going to somebody above her and saying, "Look, this scenario happened. It looks like discrimination. I'm thinking about sending in plants, would you like to deal with this in a more reasonable fashion?" Just being straightforward, a straightforward approach.
It sounds to me like you would have an extremely difficult time getting any kind of preventative or injunctive relief in that situation. I think you have to keep in mind that you no longer have a plaintiff, because your plaintiff, as you said, has left and gotten another job. You would need evidence if you wanted to get into a pattern and practice. And whether it was a plant or somebody else, there are other ways to get that kind of evidence, but you would still need either a plant, or you can file a complaint with the EEOC or Fair Employment and Housing. If they have had other complaints, they could investigate by looking into the employment or the application records of this company, and the evidence may already be there. So without seeking an attorney and using a plan to develop a new case, I would recommend that you file a complaint with the EEOC, which has an office here in San Francisco, and the same thing with the state counterpart, the Department of Fair Employment and Housing, because they do have legal authority to investigate so-called pattern and practices of illegal conduct with respect to employment.
Good advice, thank you. I was wondering, does Claudia Center have any feedback for me as well that's different?
Maybe just additional feedback. I think that's a really common scenario, and it's actually really sad to hear these stories. I think it's very common for people to get a negative response when applying if the employer sort of sniffs out that the person has a disability. And that's one reason that a lot of applicants will try to not disclose their disability, not disclose that they're with DR while they're applying, and that's just sort of a sad reality. And failure to hire cases are very difficult to litigate because your plaintiff has never even been working for this company, so you basically have very little information. All you have is a rejection, or in this case, sort of a failure to even consider. And the employer can sort of come up with lots of reasons. They can say, oh, the old manager lost it, or, oh, we hired someone that we, had some reason to hire, and so they tend to, have a lot of leeway to come up with reasons in these failure to hire cases, and that's why sometimes advocates use, we don't call them plants, but it's the same thing, we call them testers, and you do send out paired testers to an agency, one with a disability and one without a disability with comparable resumes, and to see if the people have a different experience. It can be tricky as a legal matter. There are actually consultants that lawyers and advocates can retain that to make sure that the resumes really are comparable and all that. And you have to, it can be kind of tricky because you have to leave reference numbers on the resume and the numbers have to actually work. So it's a little bit more complicated to use testing, but it's probably the only way to really attack these failure to hire situations.
The gentleman with the microphone.
Yes, I'm looking for a legal advice. Maybe Claudia, she may answer me. I have a case that I was injured 2 years ago. I had the repetitive stress injury at work.
Oh, what type of stress injury?
Repetitive stress
Oh,
injury.
repetitive stress, okay.
And my experience for the last 2 years, I think the doctors are welcome. They were viewing this problem as quite minor problem. But for me, it's all my life. I mean, this is the only thing I know to do is working using computers. Now, what they are trying, what the insurance is trying to do, that they want to close the problem, and I really don't want to do that. So I went to a lawyer, and lawyer, he said basically, since he's not getting much money, I think he said no, I will not. He refused basically to take me. And I really don't know much about this legal stuff, so I'm just seeking some advice here.
Do you want me to answer that on the workers' compensation?
Sure.
I mean, so you're on workers' compensation?
Yes.
And you have repetitive stress injury?
Yes, and they have done already the evaluation for me.
You've had a QME evaluation?
They sent me, I refused the first evaluation, so they sent me a list of QME. And
Have you selected the QME?
Yes, and I'm going to see
And you've been really careful, I mean, you researched, because they give you a panel of 3 doctors.
Yeah, just 3 doctors, so you have to choose one.
Well, yeah, you, as meaning take a process in your own case, is that make sure, you contact all 3 doctors or ask them for references, because basically what's happening is the QME will make the final determination on what your rating is.
Well, that's my big concern is I'm sure they will start from there. That will be the starting point for them.
It's a workers' compensation, and just to make it, is a no-fault insurance.
Yeah.
Okay, it's not like a personal injury case, so it's based on law, it's based on formulas. There's fee caps to it. So basically, when the QME, if he says that you're 20% injured, you've lost 20% of your capacities, there is a book and you'd be rated on that, but it's pretty much standard. There's no negotiation for pain and suffering, unfortunately. It's like having an auto accident and you have a certain amount of insurance.
Okay, but let's say they evaluated me and let's say 10%. Are they going to for the final decision?
Well, a lot of times doctors, did you choose your own doctor?
Yeah, in the beginning, yeah.
Okay.
But now since I'm going to see this QME doctor and they will evaluate the last evaluation, I don't want to disclose even with final evaluation, because to me, if they give you, let's say, I don't know, some money, that's it, right? That would be it. You will not seek for other benefits. Especially if you have the injury, it will last more than that. Basically, this is what's going to happen.
It's a no-fault insurance. Basically, it's done by formula. You can get future medical or not future medical. It's dependent on what the QME doctor says. If you're not represented by an attorney, and sometimes attorneys will not take your case if it's at a certain process or they feel that there's not that much settlement. Repetitive stress injury is really misunderstood sometimes because they don't understand that if you're not doing the repetitive movements, that you know, but once you start doing it again, or sometimes they have difficulty rating it, and now it's supposed to be rated as if you had a back injury. There's been some discrepancies with it, but hopefully your QME doctor, you know, just make sure you carefully choose that one.
But let's say it's negative. What can I do?
I'm sorry?
Let's say the result is negative. I don't like it. What should I do?
Let me say this. It's been a while since I've done any comp work, but generally choosing a doctor is very important because unlike other areas of law, it is the doctor in the workers' compensation system that will decide the percentage of causation and the amount of PD or permanent disability. And one of the things that an applicant's attorney does is help make sure that you get the right doctor. If it isn't your own personal treating physician, it could be an AME, which of course is an agreed medical evaluator, as opposed to someone who most often only gets paid by the insurance company. So general advice, which is all I can say because it's been a number of years since I've done that is workers' compensation, you should probably seek legal advice, even if it's just to make sure you're getting a doctor who isn't exclusively on the insurance company's payroll, because unlike other systems, the doctors have the power even to decide where it was caused. I mean, even if they don't really know, it's not so much up to the judge as it is in other systems. It is up to the doctor. So,
well, even for me, I wanted to be represented by a lawyer, but no one wanted me. You know.
Well, in your situation, you may, if you don't have a treating physician, you may then either choose one of those three, or see if you can get other advice and choose somebody else. They must provide you with three, but I don't think you're restricted to those three. Again, I haven't done this in about 8 years, the workers' compensation stuff, but you may want to ask the carrier or the adjuster, whoever it is who's sending you the names of the doctors, if you have any other options in choosing a doctor.
You may want to also try additional ways to find workers' comp counsel by calling, for example, the Bar Association's referral hotline, calling, more workers' comp firms, just really beating the bushes.
Thanks.
If you're ready for QME, you're probably permanent and stationary, and you can participate in voc rehab prior to be permanent and stationary. It's better to participate in vocational rehab as soon as possible because there's a $16,000 cap. So that's changed. And you can look for another attorney or go down to the Rehabilitation Bureau. Are you in San Francisco?
Yes, actually they have never offered me that option.
Well, then you need to go to the Information and Assistance Officer at the Rehabilitation Unit in San Francisco. And they'll give you, I don't know the number offhand, I should have, you just ask for, it's private voc rehab, so you'd ask for workers' compensation, because they'll give you state rehab, workers' compensation, information and assistance officer. They give you, if you're not represented, and they have a list of excellent attorneys, so just because one attorney may feel that your case isn't valuable, you could get a whole list of decent attorneys. They have a list, they will help you with legal information if you're not represented. And you should have been offered voc rehab because there's yeah, definitely. There's delays there. There's a lot of problems that may be going on. So you have to be careful. You know, okay, so
So,
there's,
so Claudia, there's no need for a medical release these days in the in the workers' compensation system before you can, the carrier's required to pay for voc rehab?
no, if I find somebody in disability management, and I think they're gonna be a qualified injured worker, all I have to do is get a release from the doctor saying they can participate in voc rehab.
Right.
Get a tentative job description, because then the $246 a week doesn't come out of the $16,000 cap, so people can have decent plans. See, it's really stinky if the insurance company does refer someone to me when they're permanent and stationary, because then plans are better if I have more time. But yes, they can start in voc rehab before they're permanent and stationary. And you probably have delays. I don't understand what's going on, but they're real conscientious about delays now because of the cap. And I'm finished.
It's 4:30 now, and we've been at it for a little over 3 hours. I'd like to thank the panelists for coming. I'd like to thank the audience for their wonderful questions. And again, remember this meeting was brought to you by the People with Disabilities Foundation. You can find us on the internet at pwdf.org. And thanks for coming.